Good morning. At this time, the court calls case number 1261077, Jose R. Bonilla versus Jorge Luis Boguada, Dora Edith Pachente, and all occupants. Can the parties please state their appearance, beginning with plaintiff first?
Your Honor, my name is Michael Bolts. I'm the attorney for the plaintiff.
Thank you, Mr. Bolts. And for the defendant? Mr. Boguada, can you please state your appearance? You're muted.
Okay.
Are you driving, sir?
No. I'm
Okay.
parked.
All right. It's my understanding you all have reached an agreement in this matter. Is that correct?
Yes, Your Honor.
Okay. Is there a settlement or an agreed judgment, Mr. Bolts?
The agreed judgment is that we'll have possession of the property today. We agree on the unpaid rent as $11,600. We agreed on attorney's fees of $1,500. The money in the registry of the court will be sent to the plaintiff. That's it.
The monthly rent amount is $1,450,
Yes, Your Honor.
and with possession to be granted today.
Yes, Your Honor.
Mr. Boguada, is that consistent with your understanding of the terms of the settlement? I mean, agreed judgment?
Yeah, the house I give the possession to the owner the 11th, not today.
Okay. Mr. Bolts, the back rent amount, is that through the 11th or through to today?
That's not been prorated. It's been eight months times $1,450.
Okay, the last month needs to be prorated through the 11th.
Okay. Let's just cut that in half. 1,450.
That's 514.
Okay, so it would be 8 months at 7 months at 1,450, and 1 month at the prorated amount.
I have 10,664.
Yes.
Okay, that sounds correct, sir. At this time, the
Yes.
court grants judgment to the plaintiff, awarding plaintiff possession, back rent in the amount of $10,664. There's $1,450 in the court's registry. The court will disperse those funds to the plaintiff to offset the delinquency. The court is awarding plaintiff $1,500 in attorney's fees, requiring a supersedious bond in the amount of $14,500 with the writ of possession issued immediately. Thank you all. You may be excused. Have a good day.
Thank you, Your Honor.
Good morning. At this time, the court calls case number 1261039, Tony Fu versus Janie Nuttall. Can the parties please state their appearance, beginning with plaintiff first? Your name,
Janie
sir?
Nuttall.
That's the defendant, and for the plaintiff?
Yeah, this Tony Fu.
Okay, thank you, Mr. Fu. It's my understanding you all have reached a resolution to this matter. Is that correct?
Yes, Your Honor. We agree to the following, Your Honor. Good morning. We agree that Ms. Nuttall will give me the continuing form to fill out for the Houston Housing Authority for the payment of September and October. I will do that. The second agreement is by the 27th of October, she will pay her portion of $739 for the October rent.
What's the date on that again, Mr. Fu?
10/27 next week, next Monday. And the third agreement is by October the 31st, 2025, she will move out.
Okay. All right, the form she's supposed to complete, those, what months do those address?
I'm sorry, can you repeat that?
You said she's supposed to complete a form and provide it to you so you can get paid for some back
Yes, the
monthly?
continuing form. Yes, she will email it to me or text it to me when I just filled it out
When
for
did she have to
continuing
do that by?
by today.
By the end of the business today?
Yes.
Okay. All right. If she fails to do all those pre-existing conditions, are you to get possession of the unit?
Yes, I would request immediate writ of possession. Correct.
All right. Are you seeking back rent as well?
Yes, but given her inability to pay, I will give her some time after the move out to pay the past due rent for June, July, and August.
Well, what's the months of those rent? What's the amount of those months total?
That will be a total of $2,434 for
Do they
the.
include any late fees or utilities or any expense other than rent?
No, that's not including any late fee. That's just her portion for June, July, and August. She did not pay.
What's the amount? You said 2,434?
Correct. Yes, 240. 2,400. Yeah.
Okay. All right, Miss Natal, is that consistent with your understanding of the settlement agreement?
Yes,
You'd agree to provide Mr. Fu by the end of business today the housing continuing form? Is that
Yes.
correct? You also
that's
agree to
correct.
you also agree to vacate the premises on or by October 31st. Is that correct?
Yes,
You also agree to make a payment of $739 on or before October 27th. Is that correct?
yes, that's correct.
All right. And you understand if you comply with all of those, that this matter be dismissed and it won't be a final judgment of eviction. However, if you fail to complete all of those aforementioned, it will result in a judgment granting plaintiffs immediate possession and back rent the moment you breach either one of those agreements. Okay? Is that your understanding?
Yes,
So if you fail to provide him with the continuing form today, then that's considered a breach and he gets immediate possession and the judgment. The same for the 27th and the same for the 31st. Okay?
okay, so I have the forms for him to come pick up.
Okay. Thank you all.
Mm-hmm.
You may be excused. Have a great day. Jet Landing LLC versus John Doe and all other occupants. Can the parties please state their appearance, beginning with plaintiff first?
Yes, Your Honor. Duke Amos on behalf of the plaintiffs.
Thank you, Mr. Amos. And for the defendant?
This is Nicholas Martinez from Maria Gonzalez.
Okay. Thank you, Mr. Martinez. All right. It is. Are we prepared to proceed with trial on this matter?
Yeah, and I believe that the defendants have a pretrial motion that they filed, I want to say on the 17th.
Okay. I'll hear you on your motion, Mr. Martinez.
Thank you, Judge. We filed the plea to this jurisdiction for this case that the court does not have jurisdiction because there is a pending title dispute regarding this certain property. So my client filed a lawsuit back in 2024 at cause number 2024-07830 in the 281st District Court to establish title to this property. That case is final. There was a final summary judgment signed in my client's favor back on August 19th of 2025. So it's over, 60 days old at this time. But under that judgment, my client is the fee simple owner of this property. And Judge, there's a long history of this case that involves half a dozen parties. We can certainly discuss that if Your Honor wants to, but at the end of the day, the district court declared that my client is the owner of this property, and the plaintiff before you today, who's Jet Lending, they had a lien on the property with a deed of trust, but according to the judgment issued by Judge Weems, that deed of trust is not valid. And just the reason for that is that there's a succession of fraudulent deeds that were signed between all the defendants in this district court case. that also involved the defendants being a mortgagor to get a mortgage from Jet Lending. So all that was done fraudulently. My client has a judgment against these other defendants for over $600,000 for their actions done, but also, of course, gives my client title to the property. So we have a final order from a district court saying my client is the owner. I understand Jet Lending, was not a party to that case, but this does void all the deeds that arrived before Jet Lending even had an interest in this property. But be that as it may, we still have a dispute one way or the other, and we would not be able to proceed forward on a eviction case at this time because we do have an issue with the title. And we believe we're the owners, but of course, Jet Lending, I know, will argue otherwise, but we cannot resolve that today at this court, Your Honor. Thank you.
Your Honor, of course, given the fact that he made these initial arguments, Your Honor, I think one of the biggest things that was left out during this particular argument is that this particular property was purchased within the time that this lawsuit was filed. And so if you list out all of the parties that are listed in that subsequent lawsuit that he filed in district court, you won't see that my client's listed. So they had no actual constructive notice in order to make a claim that anybody was attacking this particular title. At the time that they brought the lawsuit, they were more than likely they had an opportunity to amend the petition in order to add my clients or at least put them on some type of constructive or actual notice that this was going on. So, of course, our defense is using the bona fide purchaser defense just based on the fact that we had no knowledge of this particular lawsuit, and we don't understand why prior to that motion for summary judgment, we weren't included in this particular lawsuit based on the fact that at the time that Ms. Martinez filed this lawsuit as a John Doe or as herself, she was aware that there was another party that was interested in this particular property or had title to this property. They were well aware of that. And so the bona fide purchaser defense says that a transfer obligation is not voidable under section 24.005A1 of this code against a person who took in good faith, which my clients did because they gave a loan to the prior purchaser in the amount of $214,000.
Doesn't the bona fide purchaser defense have to come from the district court suit? That's not a defense in this.
Well, yeah, what I'm saying, Your Honor, is that I don't think that this case should be dismissed or today, that we should have an opportunity to reset it for some time so that we can go back and make these defenses if there are defenses that need to be made. But at the same time, I do believe that you still have jurisdiction just because we weren't listed in the lawsuit. So I don't understand how we were supposed to know that there was a claim against this particular title. My clients also left behind a bunch of letters requesting that the person who was occupying the property at the time notify them if they had any claims. We still didn't get anything. So I understand, more than likely that you're going to say that there's a title issue, but I do want to at least make those arguments.
I'm willing to evade it to see if you could get the district court, your issues addressed in the district court in short time. If not, then I'll probably go ahead and dismiss it.
Okay. And how long can we get an abatement for, Your Honor?
I'll do an abatement for 90 days at this point, and then we'll do a set for a status conference, and then we'll find out what's going on at that point.
Okay. All right. That works. That gives us enough time, Your Honor.
All right. Thank you all. You may be excused. Have a good day.
Okay. Thank you.
All right. Take care.